This audio recording has been brought to you by Laudio. Pierson versus Post, August term, 1805. Opinion delivered by Judge Tompkins. This cause comes before us on a return to a certiorari directed to one of the justices of Queens County. The question submitted by the counsel in this cause for our determination is whether Lodowick Post, by the pursuit with his hounds in the manner alleged in his declaration, acquired such a right to or property in the fox as will sustain an action against Pierson for killing and taking him away. The cause was argued with much ability by the counsel on both sides, and presents for our decision a novel and nice question. It is admitted that a fox is an animal fere naturae, and that property in such animals is acquired by occupancy only. These admissions narrow the discussion to the simple question of what acts amount to occupancy, applied to acquiring right to wild animals. If we have recourse to the ancient writers upon general principles of law, the judgment below is obviously erroneous. Justinian's Institutes and Fleta adopt the principle that pursuit alone vests no property or right in the huntsman, and that even pursuit accompanied with wounding is equally ineffectual for that purpose, unless the animal be actually taken. The same principle is recognized by Bracton. Puffendorf defines occupancy of beasts fere naturae to be the actual corporal possession of them, and Binkershoek is cited as coinciding in this definition. It is indeed with hesitation that Puffendorf affirms that a wild beast mortally wounded or greatly maimed cannot be fairly intercepted by another, whilst the pursuit of the person inflicting the wound continues. The foregoing authorities are decisive to show that mere pursuit gave Post no legal right to the fox, but that he became the property of Pierson, who intercepted and killed him. It therefore only remains to inquire whether there are any contrary principles or authorities to be found in other books, which ought to induce a different decision. Most of the cases which have occurred in England relating to property in wild animals have either been discussed and decided upon the principles of their positive statute regulations, or have arisen between the huntsman and the owner of the land upon which beasts fere naturae have been apprehended, the former claiming them by title of occupancy, and the latter ratione soli. Little satisfactory aid can, therefore, be derived from the English reporters. Barbeyrock, in his notes on Puffendorf, does not accede to the definition of occupancy by the latter, but, on the contrary, affirms that actual bodily seizure is not, in all cases, necessary to constitute possession of wild animals. He does not, however, describe the acts which, according to his ideas, will amount to an appropriation of such animals to private use, so as to exclude the claims of all other persons by title of occupancy to the same animals. And he is far from averring that pursuit alone is sufficient for that purpose. To a certain extent, and as far as Barbeyrock appears to me to go, his objections to Puffendorf's definition of occupancy are reasonable and correct. That is to say, that actual bodily seizure is not indispensable to acquire right to or possession of wild beasts, but that, on the contrary, the mortal wounding of such beasts by one not abandoning his pursuit may, with the utmost propriety, be deemed possession of him, since thereby the pursuer manifests an unequivocal intention of appropriating the animal to his individual use, has deprived him of his natural liberty, and brought him within his certain control. So also, encompassing and securing such animals with nets and toils, or otherwise intercepting them in such a manner as to deprive them of their natural liberty, and render escape impossible, may justly be deemed to give possession of them to those persons who, by their industry and labor, have used such means of apprehending them. Barbeyrock seems to have adopted, and had in view in his notes, the more accurate opinion of Grotius, with respect to occupancy. That celebrated author, speaking of occupancy, proceeds thus. requiritur autem corporalis caedem, possessio ad dominium adipicendum, atque ideo vulnerase non sufficit. But in the following section, he explains and qualifies this definition of occupancy. Sed possessio illa potest non solus manibus, sed instrumentus ut discipulis retibus laqueus dom duo adsint, primum un ipsa instrumenta sit it nostra potestate, diende un fera ita inclusa sit, ut exire inde nequat. This qualification embraces the full extent of Barbeyrock's objection to Pufendorf's definition, and allows as great a latitude to acquiring property by occupancy as can reasonably be inferred from the words or ideas expressed by Barbeyrock in his notes. The case now under consideration is one of mere pursuit, and presents no circumstances or acts which can bring it within the definition of occupancy by Pufendorf, or Grotius, or the ideas of Barbeyrock upon that subject. I think clearly distinguishable from the present, inasmuch as there the action was for maliciously hindering and disturbing the plaintiff in the exercise and enjoyment of a private franchise. And in the report of the same case, Chief Justice Holt states that the ducks were in the plaintiff's decoy pond, and so in his possession, from which it is obvious the court laid much stress in their opinion upon the plaintiff's possession of the ducks ratione soli. We are the more readily inclined to confine possession or occupancy of beasts ferae naturae within the limits prescribed by the learned authors above cited, for the sake of certainty and preserving peace and order in society. If the first seeing, starting, or pursuing such animals, without having so wounded, circumvented, or ensnared them, so as to deprive them of their natural liberty, and subject them to the control of their pursuer, should afford the basis of actions against others for intercepting and killing them, it would prove a fertile source of quarrels and litigation. However uncourteous or unkind the conduct of Pierson towards Post in this instance may have been, yet his act was productive of no injury or damage for which a legal remedy can be applied. We are of opinion the judgment below was erroneous and ought to be reversed. Judge Livingston, dissenting. Of 6 exceptions taken to the proceedings below, all are abandoned except the third, which reduces the controversy to a single question: whether a person who, with his own hounds, starts and hunts a fox on waste and uninhabited ground, and is on the point of seizing his prey, acquires such an interest in the animal as to have a right of action against another, who, in view of the huntsman and his dogs in full pursuit, and with knowledge of the chase, shall kill and carry him away. This is a knotty point, and should have been submitted to the arbitration of sportsmen, without poring over Justinian, Fleta, Bracton, Pufendorf, Locke, Barbeyrock, or Blackstone, all of whom have been cited. They would have had no difficulty in coming to a prompt and correct conclusion. In a court thus constituted, the skin and carcass of poor Reynard would have been properly disposed of, and a precedent set, interfering with no usage or custom which the experience of ages has sanctioned, and which must be so well known to every votary of Diana. But the parties have referred the question to our judgment, and we must dispose of it as well as we can, from the partial lights we possess, leaving to a higher tribunal the correction of any mistake which we may be so unfortunate as to make. By the pleadings it is admitted that a fox is a wild and noxious beast. Both parties have regarded him, as the law of nations does a pirate, hostem humani generis. And although de mortuis nil nisi bonum be a maxim of our profession, the memory of the deceased has not been spared. His depredations on farmers and on barnyards have not been forgotten, and to put him to death wherever found is allowed to be meritorious, and of public benefit. Hence it follows that our decision should have in view the greatest possible encouragement to the destruction of an animal so cunning and ruthless in his career. But who would keep a pack of hounds, or what gentleman at the sound of the horn and at peep of day would mount his steed and for hours together, sub Jove frigido, or a vertical sun, pursue the windings of this wily quadruped, if, just as night came on, and his stratagems and strength were nearly exhausted, a saucy intruder, who had not shared in the honors or labors of the chase, were permitted to come in at the death, and bear away in triumph the object of pursuit. Whatever Justinian may have thought of the matter, it must be recollected that his code was compiled many hundred years ago, and it would be very hard indeed, at the distance of so many centuries, not to have a right to establish a rule for ourselves. In his day, we read of no order of men who made it a business in the language of the declaration in this cause, with hounds and dogs to find, start, pursue, hunt, and chase these animals, and that too without any other motive than the preservation of Roman poultry. If this diversion had been then in fashion, the lawyers who composed his institutes would have taken care not to pass it by, without suitable encouragement. If anything, therefore, in the digest or pandex shall appear to militate against the defendant in error, who, on this occasion, was the fox hunter, we have only to say tempora mutantur. And if men themselves change with the time, why should not laws also undergo an alteration? It may be expected, however, by the learned counsel, that more particular notice be taken of their authorities. I have examined them all, and feel great difficulty in determining whether to acquire dominion over a thing before in common, it be sufficient that we barely see it, or know where it is, or wish for it, or make a declaration of our will respecting it. Or whether, in the case of wild beasts, setting a trap, or lying in wait, or starting, or pursuing be enough. Or if an actual wounding, or killing, or bodily tact and occupation be necessary. Writers on general law, who have favored us with their speculations on these points, differ on them all. But, great as is the diversity of sentiment among them, some conclusion must be adopted on the question immediately before us. After mature deliberation, I embrace that of Barbayrock as the most rational and least liable to objection. If at liberty, we might imitate the courtesy of a certain emperor, who, to avoid giving offense to the advocates of any of these different doctrines, adopted a middle course, and by ingenious distinctions rendered it difficult to say, as often happens after a fierce and angry contest, to whom the palm of victory belonged. He ordained that if a beast be followed with large dogs and hounds, he shall belong to the hunter, not to the chance occupant. And in like manner, if he be killed or wounded with a lance or sword, but if chased with beagles only, that he pass to the captor, not to the first pursuer. If slain with a dart, a sling, or a bow, he fell to the hunter. If still in chase, and not to him who might afterwards find and seize him. Now, as we are without any municipal regulations of our own, and the pursuit here, for aught that appears on the case, being with dogs and hounds of imperial stature, we are at liberty to adopt one of the provisions just cited, which comports also with the learned conclusion of Barbayrock, that property in animals ferae naturae may be acquired without bodily touch or manucaption, provided the pursuer be within reach or have a reasonable prospect, which certainly existed here, of taking what he has thus discovered and intention of converting to his own use. While we reflect also that the interest of our husbandmen, the most useful of men in any community, will be advanced by the destruction of a beast so pernicious and incorrigible, we cannot greatly err in saying that a pursuit like the present, through waste and unoccupied lands, and which must inevitably and speedily have terminated in corporal possession, or bodily seison, confers such a right to the object of it, as to make any one a wrongdoer, who shall interfere and shoulder the spoil. The justice's judgment ought, therefore, in my opinion, to be affirmed. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.